Hello, YouTube. I'm Vince White. I'm an employment attorney, and this is a breakdown of the different ways to pursue a workplace discrimination or workplace sexual harassment claim, right? There's really three different paths that you can pursue your case in. The first that we'll talk about is, of course, litigation, right? The most what people know and think of when they think of the U.S. court system. A civil claim, you're filing your case, you're going before a judge, you're going to get a jury, they're going to decide your case. The second is for workplace sexual harassment, workplace discrimination. There's these federal and state and often even county or local agencies that can hear your case. Now, there's advantages and disadvantages to those two separate paths, and that's what we're going to spend this video talking about. There's a third path, arbitration, right? I work as an arbitrator. I decide cases. People sit and argue in front of me. That not really in front of me anymore. Now they do it on Zoom or virtual conference, whatever it is. And that is a third path, and I'm going to create a separate video to talk about arbitration because arbitration is not available to everyone. If you don't have an arbitration agreement, and if the other side doesn't want to agree to arbitration, then you probably will not be successful in getting an arbitration filed. But that's a separate video coming later this week, next week, someday. It's on my to-do list, right? So let's talk about the advantages and disadvantages of litigation versus filing with the agencies. The big reason to file a litigation, the old classic style of getting things done, is you get a jury. You get a judge, you get a jury, you get your day in court. It feels big. It feels consequential. You feel like what you did mattered. Win, lose, or draw, you feel like you fought. And juries are unpredictable. Juries often can award larger monetary penalties against employers. A lot of juries don't like employers that much. That's great, right? That's really good news. Juries are also wild. You don't know who you're getting. Jury selection is very unpredictable. It's an art, not a science. You can watch TV shows about masterfully picking juries. Not reality. There's no mind reading. There's no knowing mannerisms mean this person's racist or something like that. You don't know. You can't know. It's not really how human beings work. Do I think I'm pretty good at picking a jury? Yeah. Am I arrogant and probably wrong? Yeah. Right? Listen, if you got a good track record picking juries, it means you have a little bit of intuition and a lot of luck. I have to accept that about myself, right? I'm a luck-based human, right? And I've been very fortunate in that my luck has rubbed off on my clients on many occasions. But that's part of the issue. Also, juries don't really listen so well. I think studies reflect, and I'm not quoting, I'm off the top of my head, best recollection, I think juries listen to something like 30 seconds out of every 5 minutes of testimony. Yeah, that's a wild figure, right? Can you imagine someone deciding your life listening to, the occasional snippet of what you experienced? Horrifying. Terrifying. Appalling, frankly, but the human attention span is what it is, and these are not specialized human beings that have practiced paying attention, right? They're just average citizens. You, me, anyone who gets called. Probably not me. Nobody's going to let me sit in a jury for an employment case. They would look at me and be like, nope, that guy's not at all neutral. We can't trust him to hear this case. He'll fine for the employee, right? Which is ridiculous. I think I'm very, very down the middle fair. But, that's who you're getting. Just run-of-the-mill citizens who are not practiced at this. Sitting and listening to a story for hours upon days, upon maybe weeks, is a tough gig. It is not easy to pay that kind of attention and really understand, right? Litigation also, another downside, kind of expensive. right? Generally, firms, lawyers are going to have to shell out a lot more during a litigation. It's a much more expensive process. Clients are often expected to share in those expenses. Whether it's being recouped after, whether they're paying it up front or contemporaneously, whatever the arrangement you have with your firm is, it's pricier. There's more to it. There's more involved. And the last thing you really need to pay attention to when you're filing a litigation is the fact that you're probably filing on a public docket. So now, for the rest of your life, it's very possible that your name in its entirety shows up on Google and in background checks as someone who sued a prior employer. That's scary. Should that keep you from finding jobs in the future? It shouldn't. Might it? Sure might. Pretty scary. And that's a concern, right? It doesn't matter if you want to do press in your case or not. Reporters can look at a docket, a public docket, and just write a story about it. They can pull the complaint up. It's publicly available. You can't stop them. Freedom of the press, right? So that's a concern. Now, most, not all, but most of these agencies, they're mostly private dockets. Now, listen, there's ways that people can get things out of some of these agencies. They can file Freedom of Information Act claims and get things from some of the agencies sometimes. It's not perfect. But overwhelmingly, if you're filing with an agency and you spent the time in whatever jurisdiction you're in to make sure that the agencies you're filing with are not blasting your information out to the world at large, there's a really good chance your name's not going to show up on Google, maybe even in background checks, as someone who brought a claim against their employer. Also, generally when you're filing with an agency, you're not technically filing a lawsuit. You're not having yourself a litigation. Often what you're actually doing is filing an administrative action. The result's largely the same. You're bringing a claim for damages. You're asking for money to be made whole for what was done to you. But if a future employer is rude enough to say, on this application here, we'd like to know if you've had litigation with any prior employers, you can honestly answer, no. You haven't had litigation. You've had administrative action, so your answer is no, right? Check that out. Make sure they're asking the question in a way that keeps you safe. Pay attention, be careful, always be honest. Also be leery of employers who ask that question. What do you want to know? What? Are you worried? Why do you feel the need to include that in an application to work at this company? Is there something going on here? Are things not on the up and up? Right? So that's another huge advantage. Now, juries, that we talked about a little bit, they can tend to assign a little bit more in terms of damages. Juries can often be very aggressive in trying to help plaintiffs, trying to help employees. Why? Juries tend to be made of employees because American citizens tend to be employees overwhelmingly as compared to employers or business owners. That makes sense. You can't have, I guess people are starting to start their own businesses again a little bit, but generally, small business is something that the U.S. government and state governments are very aggressive towards and have been slowly trying to wipe out. I don't know if they would agree with that characterization of their behavior, but that is, in my eyes, the result of many of their policies. People might argue that my behaviors, suing employers, is wiping out small business, although I would say that often these laws don't impact truly small businesses. Okay, so that's, the jury could give you more. The problem with some of these agencies is, on the federal level, the EEOC is kind of a failed agency. They're not really doing much these days. They do some things, but generally what they do is they might read your case. They might try to settle it. They might not. They might try to schedule a mediation. They might not. They might bury your case for 4 years and do nothing, and then issue you a right to sue letter. Would that be a shocking behavior on the part of the EEOC? No, pretty much par for the course. And, you really have to stay on top of them. You really got to make them work. to the extent that you're able, to the extent that they even return your calls. Now, it does not make the EEOC without value. The EEOC is a wonderful place for a case to be while you're talking to the employer. It's potentially a way for you to get some free discovery from the employer. But they're not going to, generally speaking, decide your case, and it's very unlikely they're going to assign attorneys to litigate your case. They could. Theoretically, they could. And occasionally they do. But it's unlikely. To like winning the lottery levels of unlikely here. And I'm being facetious, but only a little bit. Okay, so the EEOC has value, and you do have to file with the EEOC to end up in federal court later, right? But we're talking about, what's better for you, the agencies or litigation? Well, the state and local and county agencies, they're all different, right? Local laws are all different. All the protected classes are not protected in all the jurisdictions in the United States. Different jurisdictions recognize different protected classes. Different jurisdictions recognize different disabilities. Okay, so we got to look at how are things where you are. Are your agencies protecting you in the ways that you would need for your case to be successful? Important first question. A lot of these agencies, they're not staffed particularly well, in that they're not, there's not a lot of merit that goes into choosing the employees for some of these agencies. Sometimes, if you get elected to a position in, government, the people who helped you get elected, you want to say thank you. Maybe you just give them a cushy job doing mostly nothing, or doing a bad job, even worse maybe, in an agency that pays them, a decent salary. That's a big thank you for somebody who donated to your campaign or worked on your campaign. Just a buddy from high school, who knows, right? That's certainly something we've seen in the agencies. We've seen people who run offices for agencies that specifically are tasked with the mission of addressing workplace discrimination, who cannot define the word discrimination. Like, not even the Webster's dictionary. We're not even talking a legal definition here. Like, they couldn't give you the definition of what discrimination is. How are you going to do the job? Seems questionable, right? Some of these geniuses have said crazy things to us. You might have a very complex case with just hypothetically people from the same country. Now they're here in the U.S. and there's some kind of discrimination going on carrying over from their country of origin. Well, you might run into a supremely ignorant official, investigator, whatever it is at an agency who tells you, no, they're all the same. Can't be discrimination. They're all the same. See the what now? It's not how any of this works. There are things you need to learn about cultures to know if they're different, and they're targeting each other for discrimination, right? It's more than just, they're all from the same country. They all speak the same language. Also, again, not how we classify if there is or is not discrimination, right? So sometimes in the agencies, you get disappointing results. You get assigned disappointing government officials. I do think there's an awful lot attorneys can do to navigate around that, right? Often we approach a less than enthusiastic government official as someone whose job we would very much need to do for them, right? And that can often be very compelling for a very lazy government worker, right? If you've really put together a compelling case and you've put it all together with a bow on it and done all the work for them, and all I have to do the right thing is say, I'd like to do less. Check. Good for you. Well, that's a really easy way to win a case, right? Is it extra work for us? Sure. But we're here to help. That's what you got. That's what you hired an attorney for, right? So, yeah, there's downsides to agencies, but I do think they're surmountable. And I think it's a good option, especially a good starter option, because listen, as long as you're careful about timing and getting a decision here and all these other things, and you have to talk to your attorney about this, right? But as long as you're careful, often you can start in the agencies. And if you don't like what's happening in the agencies, you can very likely pull your case out of the agencies and go to litigation. You've had all the benefits of the agencies, all the negotiations about your name being out there and everything else, and it didn't go the way you wanted. Okay, try something else, right? That's the point. That's why you have the attorney. Try something else. The attorneys should be adding value, reducing risk, right? So don't be afraid to use the agencies. Get the discovery. Get the investigators to do whatever you can actually get an investigator to do, right? Better your position. Build a foundation for your case. Add evidence. Or if you see that that's not what's happening, okay, stop wasting time. It didn't. Negotiations have come to a standstill. We are not adding strength to our case. What do we do now? Well, sounds like it's time for a trial. And then you need to decide, is it better for me to go public and have a trial in front of a jury? Or is it better for me as a claimant to embrace a potential trial in an agency where maybe my name's not going to get out? Is my case worth so much that I can let it potentially impact my career? Or am I so brave and principled that I don't care about that and I want to go to the big show, make a big splash, stand up for what's right, and fight, right? Like that's incredible if you can do that. If you're that person, you're brave, and that works for your life, well, my hat's off to you. That's incredible. You're part of this potential solution for society that may someday put me out of a job. I can't wait, right? I hope that, this is a 20-minute video. So these are just some of the things you need to think about when you're deciding the path for your case. And I think that a lot of firms don't really have these conversations with claimants, right? There's firms who just put every case in the agencies because that's where they want them. They think it runs a little bit smoother there. There's firms who just put every single case in a public docket litigation because they want a couple extra bucks in the back end because the jury might give them more, right? I don't think that one-size-fits-all solution fits so great. I don't think it does. If you're going to retire tomorrow, but you got one heck of a claim and you're not worried about ever finding another job, well, time for the big show. Let's go get you a jury, right? You don't have to worry about finding the next job. But let's say you're 32, you've got a really good career, it's worth an awful lot over the course of the rest of your life, and you have a claim. Is your claim going to be worth enough to make it worth potentially impairing the rest of your career? Probably not. The one-size solution doesn't fit all. Anyways, I'm going to check the comments on this because I think this is a question a lot of people face, and I'm happy to give feedback. I cannot give you local and state advice in terms of your agencies locally. I'm just not going to know them all. We handle cases in the EEOC and in New York State, and some other states that the various attorneys here handle cases in, but I'm not allowed to speak to the local and state laws of other states. Only the EEOC for me and New York State. If this video is helpful, consider liking and subscribing. It really helps me to help more people just like you. Take care out there, and remember, everybody works. Not everybody wins.